Hi there, I'm Savannah Mexto with Mannor Law Group. Welcome you to another Webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. When it comes to estate plans, Bob has pretty much seen it all. However, there are some estate planning red flags he's seen more often than others. One thing all planning flaws have in common is that they can be devastating for you or your loved ones. Now, before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note, even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, we encourage you to contact us after the webinar. Also, if you have a general question during today's presentation, please use the chat box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we'll contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent out tomorrow so that you can share it with your family, your friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Mannor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He's currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. This is always a really interesting topic, and I'm going to get right into it. So one of the things that we're dealing with when we're talking to folks and realizing that this tends to be a little bit more layered than a lot of folks imagine, because when you really think about it, what do people typically go to see their attorney about? They're going to say, well, what's going to happen when I die? Which seems like a fairly simple and straightforward question. But there's a problem with that, and it's a pretty big problem, and that is that we don't have that crystal ball. We don't have the ability to predict the future. So what is the thing that we don't know, or the things that we don't know when you're doing your planning? And what we don't know is when you're going to die, how much money you're going to have, how your money's going to be situated, who's going to be living when you die, if you're going to get sick. If you do get sick, when that's going to happen? What if you ever got dementia? Are the people that you are planning on being here not going to be here? Have you moved your money around? Have you sold your house and bought a condo? There's all these things that we don't know. What's the law going to be at the time that you die? Since we don't know when you're going to die, we don't even know what the law is going to be at that time. And so the idea of estate planning is much more layered than just, well, I want my kids to each divide everything equally, and I'm putting my daughter as the person in charge of it. So that's great. That's a good start, but there's more to it than that. And so a lot of people that they do their plan without attempting to predict the future. Now, can we really predict the future? No, of course not. What we can do is build a plan that's flexible enough to deal with all of these situations. A plan that is nuanced enough that's going to contemplate these things that could happen, that people die in the wrong order, that things don't go the way that we expect, that we don't have that bank. That bank may not even exist by the time that we die. That bank might have been taken over by a different bank. We may have moved over to a credit union. We may have sold our house. We may have kept that house. We may have gone into a nursing home. We may have, one of our children may have died. All of these things, the tax laws may have changed. We may have taken most of our money out of our IRA. We may have a bunch of money left over in our IRA or 401k. And so these are all things that we have to plan for and have contingencies for. And most people don't think about that, and they say, well, this is all okay because I've got a beneficiary on my life insurance. or I sign this deed that says that the house is going to go to the kids when I die. Those are things that, well, they're acceptable. They're often going to cause lots of problems and lots of hassle and lots of cost when you die or when you get sick. So what I tend to look at is to say, okay, you've worked your whole life to achieve what you've achieved, to gather what you've gathered, to pay off your house, to have some investments, to have some money in the bank, things like that. It's not worth it to not have a thorough plan in place. And a thorough plan means that we have contingencies. We have a plan in case you get sick. We have a plan in case you have dementia, and how are we going to pay for the nursing home? How are we going to pay for home care? Things like that. We've got a plan in case people die in the wrong order. We've got a plan in case we don't want to pay too much money to Uncle Sam, and we don't want to pay too much money in taxes. And those all mean that we have to have the flexibility built into the plan. And you can't do that with beneficiary designations. You can't do that with a quitclaim deed or a ladybird deed. Okay, so many attorneys these days seem to take the approach of that it is, we do this minimalist approach and we put beneficiary designations on things, or we do a ladybird deed or a quitclaim deed. I'll tell you, those result in problems so often. I recently had a conversation with a real estate attorney. So the real estate attorney and I were talking. We were actually on opposing sides of a matter where we represented different family members. And the reason why we represent different family members is because the parent had signed a ladybird deed, which what the parent thought was, this is going to be easy. It's going to stay out of probate court and it's going to get things to my kids. Well, when I talked to the real estate attorney, he said, when people have these ladybird deeds, the vast majority of the time we just file a court action immediately for partition. So I had convinced him not to do that to see if we could resolve this first. But most of the time, he says when there's a ladybird deed that he's just as soon as he gets a hold of it, he's recommending that the family file a court action. So, most people do this because they think that that's going to keep them out of probate court, but we end up in court anyway on a petition for a partition. And so there's just so many reasons why that is not an ideal situation. And this is the primary reason, because we can't predict the future. We can't plan and have a one-page document that's going to cover all of the possible scenarios that might happen in the future. So for example, one of the things that people will sometimes do is they'll have a ladybird deed or a quitclaim deed where they think that that's going to help them avoid probate and have the property go to their 3 kids. Well, there's multiple problems with that, and I'm just going to give you the top 2 problems with that. The first problem is, what if one of those children died before you? Now we've got a problem. If it's a quitclaim deed, there's ways to do that, but a quitclaim deed is actually a gift, and we have problems because of the gifting. With the ladybird deed, it's actually unclear what that is going to mean if the person that is listed as the person that's going to receive it is going to, if they die before you. The second issue is, now we have the 3 kids all on the house together. And a lot of folks will say, oh, that's fine. They all get along. It's all going to be fine. I don't know how many times that I've had families say that, and then mom and dad die, and we've got all kinds of problems. I was just dealing with a family today where they had a property that they inherited from their parents, and that one of the siblings was living in that property. And over the time, and this was many years that the sibling was living in the property, they didn't get any benefit from it. They weren't paying rent or anything else. Then one of their other siblings died. So what do we do now? Well, the sibling that's living in the property now wants to sell it and either keep the money or at least cut out the family of the sibling that died. Is that what mom and dad wanted? I don't know. That's not, clear. None of that should have happened that way, but this type of thing happens all the time when we have multiple family members on the deed, when we have multiple siblings on the deed. So I'm not a big fan of using a ladybird deed or a quitclaim deed to transfer assets to the kids. Quitclaim deed in particular, because it causes all these gifting issues. So some people try to get around that by doing a ladybird deed, but the ladybird deed still has its own set of problems. So we like to look at a more comprehensive plan. So this is just to kind of get you thinking about some of the reasons why a plan needs to be thorough and comprehensive, and try to think about contingencies and, well, what if things change? What if I get a new bank account? What if I sell my house and get a condo? What if I get Alzheimer's? What if my children die before me? What if the law changes? What if, the tax law changes? How do I make sure that we're not going to pay too much in taxes? So these are a series of questions that I want people to consider as to why we need to do a thorough plan, and why many people have this flaw in their estate plan. So we don't know when you're going to die. We don't know whether your spouse is going to die before you, or when their spouse is going to die. We don't know, will your survivors be sick or in financial trouble or bad marriages when you die? Why do we care about that? Well, if your survivors, your child, has a severe injury and they need 24-hour care, or they're disabled or special needs, or they have Alzheimer's or anything like that, and you leave them money, is that going to be ideal? Certainly not ideal. So that's going to actually cause them potential trouble. So they might be sick and not able to manage that money. It may actually cause them harm by having that extra money, because they might have gotten benefits to help them pay for their care. What if they're in financial trouble? Well, guess what? Their creditors are going to show up on their door and say, I'm glad you got that inheritance, because we'll take that from you. What if they're in bad marriages? Well, guess what? Most of the time, they're going to lose their inheritance, or a good portion of their inheritance, to a divorce or to a bad marriage and things like that. So we don't know that. I mean, we might think, hey, everybody's in good marriage today. What about 20 years from now? What about next year? What about 3 years from now? What if their spouse died and they married somebody else? We don't know any of these things. That's why trying to do a plan that's not comprehensive, that doesn't have contingencies, that doesn't have all of these things, people people want to avoid going to a lawyer. They want to say, oh, well, I can just use beneficiary designations, or I can get this form from the internet or from the county or whatever it is. Most of the time, those are going to cause all kinds of grief and all kinds of extra expenses to the family. Will you have the exact same assets you have now when you die or when you get sick? Will the law change before you die? I can guarantee it. The law will change before you die. And does your plan adapt according to the new changes in the law? Probably not. A big law change recently was with regard to taxes as it relates to IRAs or 401ks. If your plan doesn't have a plan for that, then it probably hasn't adapted to that. When will you get sick? What if you got dementia? What if you had memory loss? How are you going to pay for care? How are we going to pay for home care? How are we going to pay for nursing home care? That's an estate plan needs to deal with that. A beneficiary designation definitely doesn't deal with that. A ladybird deed or quitclaim deed definitely doesn't deal with that. And will any of your kids or grandkids have special needs or disabilities? What happens if you leave something to someone who's on a certain type of disability? Well, they could lose their medical benefits. They could lose their disability benefits. Does that mean we have to cut them out? No, of course not. We're not going to cut them out. They can still get an inheritance. We just have to make sure it's set up properly. We have to make sure it's set up properly so that they can receive the inheritance and it's not going to interfere with their benefits. Can't do that with a beneficiary designation. Can't do that with a quitclaim deed or a ladybird deed or a will most of the time. I mean, you can do it with a will, but a lot of wills don't actually have the language in there that provides for that protection. Sometimes trusts don't have that language in there that provides that protection. It's actually fairly simple language. So it's not complicated. It should be, if somebody has a trust, it probably should be in there. But I reviewed lots of trusts prepared by attorneys that don't have those protections in case one of your kids or grandkids becomes sick, becomes disabled, becomes special needs. And the thing is, you say, well, that hasn't happened. But what about tomorrow? Do you know that's not going to happen tomorrow or 10 years from now or 20 years from now? This is why a plan really has to not predict the future, but be flexible enough to deal with the contingencies that might happen. And that's our goal, is to make sure we're thorough enough to cover those things. I'll give you a quick anecdote, a quick story about that. I had a family come to see me a while back, and they'd been a client for a very long time. And when they called up and spoke to my assistant, they were clearly upset, and they just said, we need to just come see Bob. We need to make some changes to our legal documents, changes to our trust. And usually we try to get some more information over the phone. My assistant would do that. And when she tried to do that, they said, well, we're just having a hard time. We really don't want to get into it right now. We just want to come see Bob. And my assistant said, of course, that's perfectly fine. Let's go ahead and get that scheduled. So I didn't really know what the changes were or what the concern was. I just knew that they were upset about something and that they needed to talk to me. So we get into the meeting and they said, well, this is terrible, but our granddaughter just got diagnosed with this terrible illness, and she's going to have all these surgeries, and it's going to affect her for the rest of her life. She's likely going to have to qualify for disability to help pay for her medical benefits and things like that. And so we were told that we need to come and fix our legal documents to deal with this. And I said, okay, I'm so sorry to hear that, ask more about the granddaughter. And then I pulled out their legal documents and I said, okay, well, we already have that covered in your trust. We already have that covered in your legal documents. And they looked at me kind of really surprised. They said, how on earth did you have that covered? There's no way. We had no idea that our granddaughter would get that sick, would have that problem. How could you have imagined that? And we said, well, that's my job. My job is to think about bad things that could happen and try to make them not as bad. So we had a provision in there that said, well, if any of the heirs are eligible for disability, get very sick and need assistance with paying for their care, or need disability payments or things like that, we have a provision in there to make sure that that's protected. It's frequently not in people's wills, and it's often not in people's trusts. It's definitely not in a beneficiary designation or a deed. And so the family was very happy that we had contemplated that, and that that was taken care of. But they were very surprised that we had even considered that possibility, because when they came in, all of their family was very healthy. All right, what's the next one? What's the next possible flaw that people experience? And this one is that your plan is not thorough enough or detailed enough. So I have 3 examples here. Planning for real estate. So we talked about it a minute ago. A lot of times people will, want to fill out a deed to say that their property is going to go to all 3 of their kids. That can cause all kinds of problems. Or they will say, well, this is going to my daughter. The house is, or the cabin is going to my son, or whatever it is. And here's the problem. We usually want to build some flexibility into that, because as we sit here today in 2021, you might say, well, clearly the only one that uses it and the one that really wants it, the cabin that has the lake at it, or has the stream through it, or is used for hunting property, or whatever it is, clearly that's the only one that uses it is my son. Or you say, my daughter really could use our house. That would be a great situation for her. She could really use our house. Here's the problem. Anybody see the flaw in that thought process? You're not dying. you're not dying today. You're going to be here tomorrow, and you're going to be hopefully here next year, and good chance you're going to be here 10 years from now. And is your daughter's situation going to be the same in 10 years? Is your son's situation going to be the same in 10 years, 20 years, 30 years, 40 years? We don't know. And so what we want to do is make sure that we've built in flexibility to say, well, if this doesn't make sense, we can state a preference to say, the goal is to say, hey, this has been a cottage or farmland or whatever that stayed in the family for 3 generations. I'd like to keep it in the family. And we can put some details in there to make it to make that likely. But to handcuff them to say, okay, well, turns out your son got a job in Alaska, now lives in Alaska, and there's really no chance he's ever going to use that cottage again. But now he's handcuffed because now he got that cottage, and he has to fly back here and deal with that. As opposed to, now it would have actually been better because one of the grandkids could have bought it, and they really love it, and they would have stayed there. There's just a lot of things that can come up between now and then, right? The idea is that we want to build in flexibility. It doesn't mean that we can't say those things. It means that we want to build in flexibility. We don't really want to, too often people will come in and they say, well, this account goes to this person, this account goes to this person, this house goes to this person, this house goes to this person. Okay, we can look at that and try to set it up that way, but we need to build in flexibility to say, I might not have that house when I die in 20 years. I may not, the person that I'm giving this to might not need it or want it or have any interest, or might not even be alive when I pass away in 20 years. And so we need to build in flexibility with that. One of the things that really doesn't work very well with real estate is to handle this with a deed. So often people are signing deeds, and I've done a separate webinar on this. I call it Fun with Deeds, and I'm joking when I say fun because it's a disaster. So often people think that a simple deed is simple. It's not simple. There's once a week, I'm telling you, once a week, we have somebody bring in a deed that's causing them all kinds of problems, or will cause them all kinds of problems if they don't fix it. And some of them are prepared by attorneys. I've seen some attorney prepared deeds recently that I'm just shocked by. But a lot of them, people think that deeds are a simple document. Sometimes they even hand out the forms at the county, and you just fill in the form. What people don't realize about deeds is that the exact wording is incredibly important. And so, sometimes the one or two word difference can make a huge difference as to how that property is handled and what's going to happen to that property upon your death. And whether or not you can even sell that property, during your lifetime, if you sign this deed without knowing what the consequences of that are. And frequently, because it's a one-page document or a two-page document, frequently people it will cause all kinds of problems because they just say, for example, if you said from John Smith to Jane Doe, that seems like a pretty simple deed, right? Nope, because you didn't say what that transfer entails. You didn't say how Jane's going to own it. You didn't say, so if you say Jane Doe and John Smith Jr., let's say, for example, for the kids, we've got a big problem because how do they own that? What if you said from sometimes, and this is not something to do, to give you an example. So we say from John Smith, and I've seen this done many, many times by lawyers and by others. They say from John Smith to John Smith himself, John Smith Jr., his son, and Jane Doe, his daughter, period. Guess what? You don't own the property anymore. Not only do you not own the property anymore, you can't, if one of those people die, that property is going to go through probate. If you die, because some people will do that on their deathbed, they say, okay, well, I'm going to transfer this on my deathbed. If you die, now that property is going to go through probate because you didn't tell us how you own it. Do you own it by joint tenants? Do you own it by tenants of entirety? Do you own it by tenants in common? You have to say those words, and those words are very specific. And there's other things. That's just an example. There's several other things that 3 words going to make all the difference. Does it say husband and wife? Does it say married couple? Does it say, there's a variety of things that make a huge difference on those deeds. So trying to prepare your own deeds, weekly, I'm looking at deeds that are either caused a huge problem or will cause a huge problem if we don't fix it. So people will, bring in their existing deeds and we fix them for them. Different planning for different assets. So this is very common when people think that they should use beneficiary designation. So some people will go to the effort of actually going to a lawyer, paying for a trust. And the idea of a trust is it's supposed to be comprehensive, right? It's supposed to say, okay, we're going to cover everything under this. This is our master plan, right? And so then they'll say, okay, but I've got beneficiary. I'll even kind of argue with financial advisors sometimes because they say, well, this one has a beneficiary designation, and we'd rather use the beneficiary designation here. But then what we're doing is we're having, each asset, we have a different process and a different procedure for each asset. And so now we've complicated it. Instead of having one master plan that says, this is how everything's going to go, this is what the process is going to be, we're going to have a different process and a different procedure and a different, work and paperwork and everything else that we're going to do for each individual asset. That gets particularly difficult when we're dealing with somebody that got sick. What if dad now gets Alzheimer's? And the kids are kind of trying to step up and make sure that we're protecting things, protecting assets, maybe qualifying for some government benefits to help pay for care for the Alzheimer's. And we have all of these different assets, differently situated, different beneficiaries, different processes. It can be a very difficult process to get through that. We do it all the time. That's what we're here for. But certainly it would be so much simpler for the family, simpler for the lawyer, if we had one plan that's going to cover everything. And then planning for taxes. I want to throw this one in here because taxes is an interesting issue, particularly as it relates to retirement accounts. So Roth IRAs, traditional IRAs, 401k, 403b, if you're GM, PSP, you know, any kind of retirement account. So we've got to be, how we handle the taxes and how we take the money out of those accounts is going to be very important. Some people imagine that they're going to pass away and that money's going to go to their kids and the government's just going to go away. And that's not what happens at all. In fact, they just passed a new law that took effect January 1st of 2020 that drastically changed how those accounts get taxed after you die. There's a good way to do it where we minimize the taxes, and then there's the way that most people do it because they didn't actually have a plan. They didn't have a plan. And there's a lot of lawyers that don't get into this. They don't get into the taxes on IRAs and things like that. So they just kind of leave it up to fate. Well, sometimes leaving it up to fate, if you've got a $500,000 IRA, and I know that's a lot of money, so not everybody has that, but some people do, you get a $500,000 IRA, it might be the difference of $200,000 in extra taxes that you didn't have to pay if you had done it strategically, if you had set it up properly, which is what proper planning does. And so even, you know, even if you have a smaller amount, it can be a huge percentage and a huge tax burden that could have been avoided, that money could have gone to your family and to your kids and, you know, on to help them rather than going to Uncle Sam. Sometimes I joke and say, well, the way you have your plan set up right now, you've adopted an additional child. His name is Uncle Sam. Because sometimes the way some people have their planning set up, they're not planning for the taxes, and Uncle Sam's going to take a bigger chunk of it than each individual child. So it's really something that's very important and something that we want to make sure that we plan for. All right, next thing here, and this is as important as anything else. This is the thing that a lot of people forget about, or they really just think that it doesn't relate to estate planning. And that is the estate plan doesn't protect assets in case of dementia or nursing home costs. And when I say nursing home costs, it could be home care, sometimes it could be assisted living, sometimes it's nursing home. But the idea of it is, if you have one of those diseases that requires full-time care, 24-hour care, that's not paid for by Medicare. That's not paid for by Blue Cross. That's not paid for by hospice. Sometimes people say, oh, I'll just get on hospice. It's not paid for by hospice, okay? It's not paid for by Blue Cross. It's not paid for by Medicare. We're going to be looking at veterans benefits. We're going to be, if you're not a veteran, or even if you are, sometimes we're going to be looking at Medicaid, which is different than Medicare. I wish they didn't name them so similarly, and some other government programs. But the idea is, and many of you have heard that with Medicaid, that you have to lose everything first. And that's not the answer. That's not what the law says. There's lots of ways that you can protect your assets and still qualify, but most people don't do that. And we want to at least have provisions in there that would allow your family to protect it later. So not everybody is going to protect in advance. Some people are concerned about this enough that they say, well, I want to make sure that I don't lose my house or lose everything in case I get Alzheimer's, in case I have to go to a nursing home, in case I need 24-hour home care. I don't want to lose everything I have because of that. And they plan ahead for that. That's great. We love it when people plan ahead. But not everybody wants to plan ahead. But if you don't plan ahead, we still need to have something built into your plan that gives permission to your family to do it in a crisis. Most people don't have this. If you have a will and a trust and a power of attorney and a healthcare document and all these other things, maybe even some deeds and things like that, most of those do not include provisions authorizing your family to protect assets in case of Alzheimer's, to protect assets in case of nursing home. And we need that built in there. We call it extraordinary powers, extraordinary powers. Most documents, most legal documents, most legal plans that I've looked at don't have those extraordinary powers in there. So at a minimum, we're going to want you to add those extraordinary powers. What do I mean by that? This is to give permission to your family to do the planning necessary to protect your assets if and when you need it. Why do you have to do that? Why do you have to give permission in advance? Well, here's the reason. By the time you need it, you're probably not capable of doing it yourself. So, you know, 20 years from now, 10 years from now, whatever, you say, hey, I have Alzheimer's, I need 24-hour care. I attended that webinar back in April of 2021. I better go see Bob. What's the flaw in that logic? First of all, by that time, if you need that level of care, you probably don't have the ability, the physical or mental ability to come see me. So we need you to pre-authorize your spouse. We need you to pre-authorize your kids. not necessarily to come see me. It's not going to say, go see Bob, but it's going to give them authority to go to a lawyer that does this type of a thing, hopefully a certified elder law attorney. They call it a CELA, or certified elder law attorney. It's a national board certification in elder law that helps with things like Medicaid and veterans benefits and those types of things. But the idea is I can't do my job unless I have permission to do it. And the person that can give permission is the person that needs it. Well, the person that needs it has Alzheimer's. So we better have it clear in your plan that your spouse has that permission for you, or your kids have that permission for you. That's what we call extraordinary powers. Now, you would think that's in everybody's documents, right? It's not. It's in very few people's documents. And so many, many times, if you don't want to plan ahead, we want to at least add in those extraordinary powers to authorize in case, God forbid, you got Alzheimer's or Parkinson's or vascular dementia or any of the other dreaded diseases, right? Okay. So that's those are the ones that I came up with today as the common flaws that we see in plans. And so hopefully you have some additional questions about this and you'd like to get some additional questions answered, or you'd like to come in and have us review things for you. So Savannah is going to get back on and kind of tell you about what that process looks like and how to get your questions answered and how to see us either over the computer or over the phone or in person. We have all of the social distancing things in place and the masks and all of that. We've taken this very seriously. So we have all of the options available, including in-person appointments, where we have all of the protocols in place. So Savannah, if you want to take over and kind of explain that process.
Absolutely. Thanks, Bob. And thanks everyone for joining us today. As Bob mentioned, we do have a couple of easy ways for you to contact our team. Maybe you just have a question, maybe you want more information, or maybe you heard something today that really stuck out and you want to take some action. We're here. So you can give us a call. Our phone number is 810-694-9000. Or if you look in the chat box, I've gone ahead and put a link in the chat box. That link allows you to go to a calendar and you'll choose a day and a time when a member of our team can call you. So again, if you know right now, I don't have time to talk now, but I'd like to talk later, go ahead and click that link, schedule a time, and we'll reach out to you then. But of course, you can always call. We have two phone numbers. Our local number is 810-694-9000, or you can reach us at 1-800-990-6030. I will be sending out an email maybe in about 10 minutes or so that will have that information in there for you as well. And tomorrow I'll send out the replay of today's video. And again, I encourage you to share that video with family, with your friends, or with anybody in your network who you think could benefit from hearing this information. Thanks again for joining us today. Have a great day, and we will see you next week.